Hello, everyone. Hello, everyone. Welcome back. I hope you enjoyed this morning's session on protected disclosures and reporting channels. If you did miss it, you can please just check out the OneDrive folder where all the recordings are there, so you can watch them back in your own free time. Now, I'm just going to do a little bit of housekeeping. So just a reminder again that all the bios for the speakers are on the Integrity at Work website. And if you're on socials, please do check out our latest posts about the conference and share with your networks using the IAW conference hashtag. And again, each of these sessions are designed to be as practical and interactive as possible. So we've got the Q&A function, which we'd love you to utilize. If you can submit your questions into the Q&A as they occur, the panel will get back to as many of those questions as they can by the end of the session. And of course, if you have any questions about the session or the conference in general, you can email us at events@transparency.ie. Just one last reminder, we're holding our in-person event at the end of the week, so on Thursday evening in Dublin. So if you missed earlier, this is your last chance to RSVP. We'll pop the RSVP link into the chat, but you can also email us at the event's email address to let us know whether you want to come to that. Just to remind you that there'll be drinks and food provided, and it's going to be a really interesting discussion with former Uber lobbyist and whistleblower Mark McMahon and the Irish Times Carroll Lillington. They're going to discuss the importance of transparency, accountability, and trust in both corporate and public life. And there's also an opportunity at that event to network with other conference attendees and guests over those drinks and nibbles. So this is the first time we've been able to do an in-person event in 3 years. So we're really excited to see as many of you there as possible. So please do sign up for that today. It is your last chance to do that. And now on to our session today. So this afternoon, the panel will be discussing the new rights and responsibilities for those reporting, those responding, and of course, employers around protected disclosures. Moderating the session is Dr. Vigjilenca Abazi. She is the co-founder and executive director of the European Whistleblowing Institute. Vigjilenca is a legal scholar renowned for her expertise in whistleblowing. She is a trusted voice in policymaking. Her contributions include co-drafting the model EU whistleblower law for the European Parliament, authoring reports for the Council of Europe, and overseeing compliance monitoring for the European Commission. She was also co-created the Whistleblowing Now and Then podcast, so do check that out. That was with the Whistleblowing International Network. And she's contributed to many books and articles on this topic, as well as delivering lectures at esteemed universities. So her full bio is up on our website, as well as all the bios of the other panelists today. So without further ado, I'm going to hand over to Vigjilenca. I think we are possibly still waiting on just one of our panelists joining, but he should be with us very soon. But I'll hand over to Vigjilenca and we'll kick off the session now.
Thank you very much, Nadia, and good afternoon, everyone. Thank you so much for joining us. Hello from the Netherlands. I hope the weather is not as rainy as it is here, wherever you are. We have a really wonderful panel today. I could not be more honored to lead the discussion with fantastic experts that approach the topic from different angles, as you will hear in a moment. Together with us today, we have Dr. Simon Gerdermann, a German scholar who's leading an important project on observing and analyzing compliance of the German implementation of the EU Whistleblower Directive and analyzing and discussing EU whistleblower law more broadly. Also joined with us is Andrew Carroll, who is representing the Data Protection Authority in Ireland. And we will be joined shortly, we hope as well, by Ray McMahon, who's the Chief Superintendent at the Garda division. You will I don't want to at all stop the time, block the time from our speakers, actually, because we do bring important issues. The one thing to say is that to remind you that the theme of our panel is looking at the rights and responsibilities, but also sort of challenges that are emerging from conflicting challenges that are emerging from the whistleblowing sphere. Some of these challenges and some of these conflicts, as the speakers will point out, are inherent in the very nature of whistleblowing. So sometimes the law can be limited in how it can navigate those challenges, or sometimes the law itself creates these tensions between the rights and responsibilities. And that too, we will look into what is taking place, especially in light of the amended Protected Disclosure Act, and how specifically the experience in Ireland can be useful in learning both from past practices, but also what the new sort of context will be in light of the amended Disclosure Act. So without further ado, I will first give the floor to Simon, who will focus particularly on the data protection challenge, on the transnational legal implementation for the whistleblowing. Simon, the floor is yours.
Thank you very much, Vigjilenca, and good afternoon, everybody. As Vigjilenca has already said, I'm usually looking at whistleblowing from a transnational perspective. So what does that mean? You're all in Ireland, and you know that many international corporations seek Ireland as their principal seat of business for various reasons, one in particular. So what many Irish companies, especially the big ones, are necessarily going to be faced with is how to deal with transnational whistleblowing cases. That means basically two things. One thing is what happens if a whistleblower from another country is blowing the whistle to Ireland or through a channel that is situated in Ireland, or if somebody from Ireland is actually blowing the whistle to another country, especially in a multinational corporation. And the other aspect of it is how do we actually account for that? How do we set up an organizational structure that does actually account for international or transnational whistleblowing cases? For those of you who have already dealt with the new Irish law, as well as other whistleblowing laws, which are based on the whistleblowing directive, you'll find out pretty quickly that the directive doesn't really help you and the laws don't really help you in that matter. Because even though it is a European law, it doesn't detail what happens in European as in transnational cases. So what that means is you're mostly left to your own devices, but you can make it work. You can go above and beyond to set up an international channel that actually works and that can protect whistleblowers. What that requires, however, and we will go into that probably in further detail later, is that you actually set up your own rules, which make sure that whistleblowers are protected, not just in the cases which are protected on the Irish law, if an Irish person is blowing the whistle on an Irish breach in an Irish company, but also on international law. So that is my main focus, and not to steal too much time from my other panelists right now, I'm going to keep it like that and just teasing the problem, and I'm sure we'll get to the answers soon. Thank you very much.
Thank you, Simon, so much. And thank you so much for being so proper on the timing. And indeed, as you say, we're just sort of teasing out the topics in this first round of our turnaround. And then we're absolutely trying to make sure that we have more than generous time for Q&As and engage with the questions and concerns of our attendees, which are sort of the center point of dealing with within the panel. Andrew, may I invite you to join us now for a very different kind of, but equally important challenge on the data protection aspect, indeed within the specifically within the Irish context. The floor is yours.
Thanks very much, Vigjilenca, and good afternoon, everyone. What I propose to do to kick things off is to provide an overview of how the DPC handles protected disclosures in our capacity as a prescribed person under the Protected Disclosures Acts, and how this differs from our core complaint handling role under the GDPR, whilst also showing, hopefully, that fundamentally our protected disclosures role fundamentally complements our core regulatory function and is not an alternative to it, and does not sit in tension with it. So many people will be aware that the DPC is Ireland's independent authority responsible for upholding the fundamental EU right of data protection. And we have a very important role at national and EU level in enforcing EU data protection law, most famously the GDPR, but also the e-privacy directive and the law enforcement directive. However, the DPC also has important functions under Ireland's protected disclosures legislation. We are what is known as a prescribed person under Section 7 of the Act, This means that employees can make protected disclosures to the Data Protection Commission regarding relevant wrongdoings where they perceive that those wrongdoings concern compliance with data protection legislation. Now, because data protection and protected disclosures are conceptually distinct regulatory frameworks with fundamentally different purposes and goals, there are a number of important differences in terms of how we will investigate a data protection complaint under the GDPR as opposed to a protected disclosure under the Acts. So I could probably fill the whole hour going through all these differences in procedures, but just to give a couple of quick examples, because of the focus on individual rights in the GDPR, a complaint made under the GDPR will generally concern an individual's personal data and in their personal capacity. So the GDPR would generally preclude a situation where an employee would directly raise data protection concerns in a professional capacity directly with us, because those sorts of concerns should be raised in the first instance with the organization's data protection officer, who would then engage with us. Furthermore, a GDPR complaint will generally have to relate to your own personal data. So unless you're acting on behalf of a minor or a person who lacks competence, you really don't have enforceable GDPR rights in relation to other people's data as a general rule. However, when making a protected disclosure to the DPC, on the other hand, these sorts of limitations don't apply. A worker can make a protected disclosure to us in relation to any information which they come across in a work-related context and which they reasonably believe is evidence of one or more relevant wrongdoings as defined in the Act. And we will accept that protected disclosure provided the person reasonably believes that it's our responsibility to investigate, it falls within our domain, and they reasonably believe that the allegations of wrongdoing are substantially true. Now, a couple of other quick differences is that in a GDPR context, we would generally need you to provide proof that you first contacted the organization and gave them an opportunity to facilitate your data protection rights. That obviously doesn't apply in a whistleblowing context where you can come straight to us. And finally, when investigating a data protection complaint, we would generally need to identify you to the data controller, that is the organization that has your data. Whereas in a protected disclosures context, we will of course treat your complaint as confidential. Your disclosure is confidential unless absolutely required under the Act to disclose your identity. So all of this to say that our procedures for handling GDPR complaints differ significantly from our procedures for protected disclosures. But in both cases, our role is fundamentally the same. It's to enforce data protection legislation. Now, this might seem confusing to our audience at first glance, but the way to think about it, I suppose, is that our role under the Protected Disclosures Acts is another means by which we can gather information to ensure compliance with data protection law. It's another perspective, if you will, and it also avoids a situation where whistleblowing on data protection matters ends up being in the lap of another regulator besides the DPC. So that's basically an overview of how the Protected Disclosures process works and our role within it. I hope I'm okay on time, Vigjilenca.
Absolutely, and I'm actually very impressed considering the depth and the complexity of this topic that you managed to sort of really give a very succinct overview. And I hope I'm sure actually there will be a lot of questions. I personally have quite a few. But before we get into that, I want to pass on the floor to our next speaker, Mr. Ray McMahon, who will discuss the topic of challenges and rights and responsibilities from a perspective, also from his experience from the Garda division. Ray, the floor is yours.
Thank you, Vigjilenca. I suppose the first topic I'd like to talk about maybe is just about crimes that may be contained within a protected disclosure. I suppose coming from a policing perspective, but also from a perspective of a designated person and a protected disclosures manager. Just a health warning on this. This is new legislation. It hasn't been tested. So I'm really drawing on my experience both as a criminal investigator and a PD manager. And just to wish to highlight issues here, just make you aware of the legislation. And what I'm giving really is my own personal opinion, and it's only my opinion. But it just may set the scene for further discussion, because the Act is now, it hasn't really been tested. We don't have all the answers here on this yet. So just discuss certain matters that I can see presenting themselves. So just dealing with, let's say, crimes. So majority of PDs, protected disclosures, you're going to have that relate to governance, relate to process issues, maybe bullying, but occasionally there may be some crimes within those protected disclosures. And obviously the amendment of our new Act requires you to forward those crimes to Garda Síochána or to the Protected Disclosures Commissioner. Now, just that you're aware as well, the Protected Disclosures Commissioner don't have a role there in relation to assessing the PD, but more about where that PD should go to. So if it is referred to us, our job under the Garda Síochána Act and Section 7 is obviously one of our key roles is to investigate crime. So we will investigate the criminal aspect of that. But I think you should also be aware that it doesn't negate if you are a designated person, it doesn't negate what your responsibilities are other than having the actual crime part investigated. There may be a lot of other aspects within that. It's just to be aware of that. We will investigate that crime aspect. Now, if that's done, I think what's important to remember is that we're now into the realms of a criminal investigation procedure, which generally tends to take precedence. And it, as I say, it doesn't mean that the rest of the PD shouldn't be dealt with, but you should be careful not that your follow-on, the rest of the stuff you're looking into doesn't interfere with the criminal investigation. Now, obviously, things that may affect health and safety, life issues, obviously they're going to take precedence in relation to that. The criminal investigation, we need to be aware as well that in most cases a statement is going to be required from the person who's making the complaint, and that statement is always taken under Section 21 of our Criminal Justice Act, and in that there's a declaration where you declare that the evidence you're giving is true to the best of your knowledge and belief, and that you're liable to prosecution if you state anything which is false and not believed to be true. Now, that's essentially a conflict with what there would be under the protections of the Protected Disclosures Act to the protected disclosure. So it's just to be aware that that conflict is there, that if we go in with a criminal case, that it may not necessarily be the case that those protections still exist. And obviously, as I say, it comes with a health warning because that really has to be trashed out and probably what will be a court of law at some stage, but it's to be very aware of that. And I suppose a key point that it's important for, let's say, for designated persons, it is important, that if we can have the PD framed in such a way that maybe it doesn't identify individuals, but more identify the issue involved. So if, for example, there's money missing from a till, that you're not saying such and such a person took it from a till, more that there is money missing from the till and it went between whatever time or whatever time. It protects that disclosure a bit better if we can, just to be aware of that. And also be aware that I think because of that, confidentiality is not absolute when we're investigating crime. And that's just the fact of the matter. The investigation would require, if they're a particular accused, the evidence against that accused has to be disclosed to the accused. And that may and most likely will identify the source of a disclosure, not at all circumstances. And obviously protections are provided under Section 16.2 of the Act in relation to that. But I think it's very important for people who are either making disclosures or who are dealing with people who are making disclosures just to be aware about those. And my advice here really is any person dealing with a disclosure should engage them in relation to the crime and just make them aware of the potential ramifications. Obviously, we want crime to be reported to us, but I think that person, to be fair to them, should be aware of what the potential ramifications may be, because with this act, we're still not fully sure how that will play out.
Thank you, Ray, so much. I kind of muted myself and stayed muted because I didn't want to interrupt despite a bit of the overtime, because I think you're bringing really important points around the tension that we, of course, want to deal in this panel, which is also matters of confidentiality and problems around as well of anonymity. And in this respect, I know, Andrew, that you actually also have a few concerns, but also a main message around for our attendees in terms of to recall the theme of the conference overall for integrity at work this year is going above and beyond. And each of our panelists today also wants to sort of make sure that there's a clear message in terms of in their respective field, what going potentially above and beyond can look like. So Andrew, may I pass on the floor to you in terms of taking this aspect further?
Absolutely. Thanks, Vigjilenca. And I have to thank Ray for teeing me up perfectly there with his advice about protecting the identity of the whistleblower, because as we know, data protection legislation and whistleblowing legislation are fundamentally distinct legal frameworks with different objectives and purposes, namely to uphold the fundamental right to data protection on the one hand, and to allow workers to report potential wrongdoing in the workplace without fear of retribution on the other. And because both of these goals are entirely commendable and in the public interest, it can be a particular challenge for employers to navigate their rights and responsibilities when these two frameworks appear to be in conflict. But I hope to show over the course of my comments that in practice, however, a common sense approach to both will allow employers to effectively handle protected disclosures while respecting the right to data protection of those concerned. So part of the difficulty, I suppose, is that the making of a protected disclosure will, in almost all cases, involve the disclosure of the processing of personal data. Even in the case of an anonymous report, there will likely be at least an email address or a phone number or some other information which can be traced back to reveal the identity of the person who made the disclosure. And perhaps the most likely scenario where tensions may arise between whistleblowing in the workplace and data protection rights is where a person other than the reporting person who is maybe implicated in the alleged wrongdoing at the heart of the disclosure seeks to exploit their rights under the GDPR and related laws to effectively prevent the protected disclosure from going forward. So, for example, they could try to use their right to a copy of their data to try and get information that could reveal the identity of the whistleblower. They could use their right of erasure to try and force the deletion of the investigation file. So employers will have understandable concerns about how to respond when a third party tries to use their data protection rights in this way. So, there's no silver bullet, and these sorts of concerns will have to be addressed by employers on a case-by-case basis. But I think it is important to remember that the right to data protection is not an absolute right, and the GDPR makes clear at recital 4 that it needs to be understood in relation to its function in society and balanced against other fundamental rights and freedoms. And in particular, Article 23 of the GDPR sets out explicitly that EU or member state law may restrict the rights provided under the GDPR to pursue important objectives of public interest in a necessary and proportionate manner. So it is baked into the GDPR from the outset that laws such as the Protected Disclosures Act and the Whistleblowing Directive can affect and curtail data protection rights where it is necessary and proportionate and in line with the common good. And the amended Act specifically introduces new provisions where, in certain circumstances and where necessary and proportionate, the rights of data subjects under data protection law can be restricted in order to carry out the purposes of the Act. So, the handling, the investigation, or the transmission of a disclosure report. The restrictions generally apply to the extent necessary. So, for as long as is necessary to prevent the investigation of the wrongdoing from being frustrated in the ways that I've described. So the amended Protected Disclosures Act sets out both general and specific situations that Ray discussed earlier where data protection rights may be curtailed where necessary and proportionate to allow the proper functioning of the objectives of the legislation. Now, just very quickly, I'd also like to make two very general comments specifically on the right of access, which will be important for today's audience to bear in mind, which apply outside of the context specifically of protected disclosures, but which are also very relevant. The first thing is it's important to remember, as I mentioned earlier, the right of access, the right to have a copy of your data only applies to a copy of your own data. So it doesn't apply to someone else's data. And it's important to bear that in mind, even just regardless of the restrictions under the Protected Disclosures Act. And the second thing is that a right to a copy of your data under the GDPR does not mean a right to a copy of the original documents. So we're providing copies of the actual documents themselves, might pose challenges from a protected disclosures compliance perspective. It's perfectly open to you to provide redacted copies of those documents or just even just copies of the personal data itself. And this has been established by the recent case law of the Court of Justice of the European Union. The right to a copy means a copy of your data, not a copy of the actual documents. Now, none of this is to say that employers have a green light to start paring back or disregarding an individual's right to data protection where it poses a headache or an inconvenience in terms of handling a protected disclosure. Any restrictions need to be deployed carefully and proportionately, and there should never be a blanket refusal to provide any information to a person implicated in a protected disclosure who makes an access request. But all of this to say, we can see from the provisions of the GDPR and the acts that I just referred to that these are not novel problems, they are not unforeseen problems. And both pieces of legislation provide clear tools and principles for employers to apply going forward where they appear to be in tension with one another. So a common sense approach will likely resolve the vast majorities of issues, in my opinion.
Thank you, Andrew, very much. This only sort of opens the Pandora box of more questions and issues that I'm sure our attendees will also have in their daily practice in their work. Andrew, with the points that you're making on the tensions between the data protection and whistleblowing, Ray, sounds similar to some of the tensions you were pointing out between the confidentiality. So coming back to you, in the sense of aspects of the surface of what the new Protected Disclosure Acts and amendments are bringing forward, well, what is your sort of message of going above and beyond for our attendees to take away?
I think it's important as well to be aware of some of the other criminal offences that are now contained under the Amendment Act. I suppose where previously some of these breaches were breaches in themselves, they're now actually criminal offences. And I think people who are dealing with protected disclosures and managing that whole side of it should be aware of that. And it particularly comes under Section 14 of that Act. And just to list them, you've got hindering or attempting to hinder a worker making a report, penalising or threatened penalisation, including to related persons or entities, bringing vexatious proceedings, and breaching the duty of confidentiality to reporting persons, and failing to establish and maintain or operate internal reporting channels. Now, I think what's important, and it's very important in the Amendment Act, that they're now criminal offences. And some of them are very relevant to any of you who are designated persons, but it's also important that you recognise that these crimes could be committed by other people as well. So when you're looking at what may potentially be a disclosure, well, are there crimes within there that are committed by other people? So, for example, if someone had made a disclosure and they alleged that they were being bullied at work because of that, now maybe before this that might have been dealt with under a bullying policy at work, whereas now actually we're dealing with a criminal offence. So it's important that is known and people would be aware of that. I think separately as well, there's a potential conflict between what's 14.1d, and that's the confidentiality. That's the breaching of the duty of confidentiality to reporting persons, and what's under Section 16.2, which allows breaches for the purposes of the investigation. And you know what? Where is this trashed out? Where is the dividing line between what is one and what is the other? And in truth, it hasn't really been tested. And we have to take a very pragmatic approach to it. And I think Andrew has spoken very clearly towards that sort of approach in relation to GDPR issues. Now, I think the other thing that's important to remember is these offences are not what we call indictable. So in effect, we investigating them can't arrest for them. So there's no power of arrest in relation to them. But or should I say arrest and questioning in relation to them. So if we were investigating those in those circumstances, we'd only be inviting persons to participate, you know, particularly the person that may be accused. But it wouldn't be a case of to be arrested and questioned in relation to them. Now, again, as per my previous point, you know, it may also leave the disclosure open to identification. And again, you know, we sort of trashed that out again and probably will do a bit more. I think what's important with all of this is that really you should be ensuring that your policies, that your memorandums of understanding address some of these issues and what your approaches to these issues should be. That goes from what I previously spoke about and what I'm talking about now.
Ray, thank you so very much for these very clear points. And just in interest of time, that we actually have more ample time for discussion. But before we get into that, I want Simon to bring back the conversation to you. As you said, teased out some of the real challenges. And as we know, actually, Ireland is home to so many companies and different bodies that are relevant and that have so many different workers from across Europe and the world. So it's very prevalent, this issue of the transnational element that you're mentioning. I bring back the point to you in terms of where we take the discussion forward and the issues that you're identifying, and sort of as we, again, to be within the theme of the conference, going above and beyond what that means from a perspective you're taking.
Thank you very much. I think the best way to tackle this issue is just to have a practical example. If you have your Irish headquarters and then you have your couple of subsidiaries across Europe, maybe a Spanish one, and you're thinking, wait a minute, the easiest way for me to go about this is just set up an internal reporting channel in Ireland, and then I tell everybody across Europe, come on, just report to me, guys. That's not going to fly for a couple of reasons. One is that you're probably going to be violating the Spanish whistleblowing law, because you have to set up an internal reporting channel in every subsidiary with 50 workers or more. So the centralized version doesn't work. And then if that Spanish person is actually reporting something to the headquarters in Ireland, they will not be protected by the Public Disclosure Act, the amended one in Ireland, because they are not situated in Ireland, and therefore the employment law of Ireland usually doesn't apply to them. Then again, you have the problem if you think that those people could actually rely on the Spanish whistleblowing law. They're going to have two other problems. One is an international channel somewhere in Ireland is probably not going to be a reporting channel, given the understanding of reporting channels under the Spanish law. And second, they will probably be reporting breaches that are not covered under the Spanish law, and therefore the protection is going to be a bit difficult. So what I'm trying to say is the whistleblowing directive and the many national whistleblowing laws that have started to pop up after the past couple of months are not really going to help us with this. For those who dive deep into it, look at Rome 1 and Rome 2, the regulations, they're not going to help you with that anyway. So what you got to do is you got to go above and beyond in the sense that you create something that will protect people and justifiably give them not just the impression, but the reassurance that they're going to be protected, no matter which weird kind of conflicts will be coming up under international law. So what you can do voluntarily, as the simplest solution, is say, hey, I'm going to have a binding directive or something in my company, and say, whatever country you're from, wherever you're going to report, if that report is protected under at least one statute of one country, you're going to be protected here from any kind of retaliation in our company, in Ireland, in Spain, it doesn't matter. Then you can set this up. And what you would always have to, maybe the last thing, consider is that if you're going to have a reporting channel at the headquarters level, which is very advisable in many ways, then you would also have to have little reporting channels in your subsidiaries across Europe or wherever your workers may be.
Thank you so much, Simon. So attendees, I hope we haven't scared you off with all these conflicts and tensions and rights and responsibilities, and they seem to be growing by the minute in terms of all different directions. But in terms of the purpose of this panel is precisely to address your concrete questions and concerns in all these different fields from our excellent experts in their particular profession. As well as, of course, I would like to mention the fact that TI has created a help desk as a virtual resource, which will provide research responses to questions from member organizations that relate to best practices in dealing with protected disclosure cases. And this will be launched by the end of this year. So in that sense, you will have additional support and help in receiving professional and best practice supported answers. So the floor is absolutely open for Q&A. I please encourage you to either put your question into the Q&A and I will make sure that that's addressed. And in the meantime, while maybe you're doing that, I would just like to come back to the point that you're mentioning, Andrew, also in terms of the data protection, of course, having its limitations. If you could elaborate a bit more in terms of how would that work in terms of the fact that whistleblowing actually too is in a way a limited right. So it's not a fundamental right in any way. In a concrete case, if you really have to decide, sort of you have a tension between the two, what internal guidelines or what steps would you sort of envisage? And maybe perhaps that's already been potentially the case. I certainly know from colleagues from other countries where sometimes the tension of using GDPR not to disclose information in a whistleblower context or vice versa has also been the case. So if you have any thoughts on this particular aspect.
Certainly, Vigjilenca. And before I answer, can I just quickly touch upon a point that was raised earlier? It's just important to note from the perspective of our audience, a Irish audience primarily, I understand that for the purposes of the Irish Protected Disclosures Act, in the context of reporting wrongdoing, it's immaterial whether a relevant wrongdoing occurs, or would occur in Ireland or elsewhere, or whether the law applying to it is that of Ireland or another country. That's not to contradict anything that was said earlier. I just wouldn't want any of our audience to walk away with the impression that if they made a protected disclosure here in Ireland, that they lost the protection from retribution because of this jurisdictional issue that, at least in terms of the protection of the reporter, that is absolutely cast iron as far as I understand.
Andrew, you went back to being muted, and we certainly don't want that.
Sorry, Butterfingers
No
here. Yeah, sorry, specifically in relation to your question though. So in our capacity as a prescribed person under the Protected Disclosures Act, we have seen an increasing number of protected disclosures made to the DPC in line with the expanding scope of application under the 2022 Act. So whereas we received 13 submissions in 2022, we already have over 20 so far this year. And this is likely due to a combination of factors such as the expanded classes of people who are considered workers within the meaning of the Act and the broader definition of a working relationship. So it just brings more potential protected disclosures as regards data protection law into our ambit, essentially. So, I mean, in terms of the trends we are seeing or particular cases, I suppose a reoccurring theme is, misapprehensions on the part of prospective whistleblowers regarding obstacles that might discourage them from reporting wrongdoing, to the DPC or to another prescribed person. So one misapprehension that we touched on earlier is that one must exhaust their employer's internal reporting channels before making a protected disclosure to the DPC. So we often see that in the context of our disclosure, someone explaining that they've hit a brick wall internally and now they're turning to us, whereas we would explain, well, you didn't have to do that. You can come straight to us if your alleged wrongdoing is admissible. There are also concerns around the duty of confidentiality owed by the DPC as a prescribed person. So whistleblowers will come to us with a pseudonym or otherwise decline to identify themselves when making a protected disclosure because they fear retaliation from their employer. And so this raises issues in terms of explaining to the individual concerned that we won't treat their complaint any differently depending on whether or not they reveal themselves to us. But also, as others have touched upon, it's important to clarify in such cases that the employer may still deduce their identity from the context. I mean, most employers are actually quite small, and most of the time these concerns will already have been raised internally, so it will be very easy to deduce the identity of that person. And then we have to make sure that they understand this before we engage with the employer and that those protections under the Act apply. And then also it's important to remember that we only investigate data protection matters. So it's also often the case that we might be in receipt of wide-ranging concerns, which, through the narrow data protection lens, don't actually pass muster. So there would be a broad report that touches upon employment issues, upon personal grievances, upon criminal matters, and we can't accept or investigate any of that. So the challenge is therefore really, in terms of going forward and handling more protected disclosures as a prescribed person, is this transparency and empowerment piece to ensure that individuals understand the protections that apply when making a confidential or anonymous report to the DPC as a prescribed person, and by extension to empower all workers to report wrongdoing related to data protection in the workplace. So making the legislation work fundamentally.
Thank you, Andrew, very much. And actually, the point that you just brought up in your example around the fact that people, while reporting to one prescribed person, for, let's say, even a matter if it's largely about data protection, will still have these other issues which go beyond your mandate and your competencies to deal with, is something that actually that came forward even when Ray and I were talking in preparation for this panel, which is what happens in terms of the interactions between different prescribed persons and the mandate that sort of maybe they are dealing with issues that potentially are part of the police work or go beyond that scope. So in that sense, Ray, I want to bring it back to you, especially for the Irish context. And in the meantime, there's also an additional question that I will come back with. So thank you so much to the attendee who put that forward. But to focus from this point a little bit, if you have any thoughts around this interaction of different prescribed persons and the challenges in that regard.
Yes, and we do have experience of that with a number of, and it's becoming more common now, particularly when some of the protected disclosures are then referred to us through the Protected Disclosures Commissioner. And obviously we do liaise closely with GSAC as well, our investigative body into what we do. I think the key thing here is that if there's any discussion with anybody else, that really should be made in consultation with the disclosure and that they're aware and agree to it. And that's really the guiding principle that we go by. Now, obviously, there are certain exemptions under Section 16.2 where we can go ahead with that anyway and have those discussions, should we see it. But we generally tend to find that, before we go discussing it, we talk to that discloser and we have agreements with them in relation to that. So then there's no real ambiguity in relation to it. And there's also, we have to talk about, keeping that trust there. And I don't think things like that should be done without talking to disclosure in relation to it if we can at all.
Thank you very much, Ray, for your clear answer. And in this regard, actually, I'll immediately follow up with you because one of our questions from attendees is important in this regard. And the question is around what an alleged victim should be taking action, at what point, rather, of penalization arising from a protected disclosure would be encouraged to make a criminal complaint to the Garda about that penalization. Would the victim first have to make an internal complaint, bring forward civil proceedings, or would the penalization have to be been established in some other way? I hope the question is clear. That was brought forward by the attendee. So basically, the gist of the question is that around sort of identifying potentially the point where an alleged victim of penalization would be encouraged to make a criminal complaint to the police about that penalization.
Yeah, and look, what we certainly find is that all circumstances are going to be different. So there's no general rule. There's nothing to stop that person going to the designated person that they're dealing with and saying, look, here's an issue, I have an issue here. I consider it a criminal offence. I'd like to investigate it as such, for it to be passed on to us through the various channels. But there's also similarly, any victim, any person who feels that they're a victim of crime can make a report to the Garda Síochána, and we investigate it accordingly. So those channels are both open. I suppose is the short answer to that. I suppose my advice would be, providing there's no conflict, but to go back through the designated person so that everybody is aware of what the issues are and that there's no two different channels and two different streams, because it will have to go about full circle anyway.
Thank you, Ray. Thank you so much. And to the attendee asking the question, please do have a follow-up freely if in case you want to have a particular aspect to your question further addressed. I'll move on now to a question that more goes in the direction of Andrew's presentation for, I believe, more the data aspect protection. And Andrew, I believe maybe hopefully you can read the question also yourself and maybe understand the intricacies even more than I do, despite the fact that I teach a privacy course. I feel this even goes beyond my sort of technicalities. So basically the question to, let me pose it so for all attendees to have it clear, if we start a disciplinary action against a staff member based on a whistleblowing report and they put it in a DCAR, can we withhold documents based on the fact that they might disclose identifying details which could expose the whistleblower? Let's keep this first question first, and then we go back to the second question following from the same attendee.
Thanks, Vigjilenca. I actually read the question, just in real time, so I don't mind answering both limbs. Well, the second limb is actually quite easy to answer because I don't think I can comment on questions relating to unfair dismissal specifically because that's outside the remit of the DPC. But again, going back to this issue of balancing data protection with obligations under protected disclosures legislation, I think it's quite clear from the legislation itself that no one ever envisaged the right of access to be this kind of magic wand that would overpower or trump the obligations of employers under other areas of law. So, there is ample scope to curtail or restrict the right of access where it basically makes common sense to do so. So I've already mentioned recital 4, which talks about the very high level, data protection doesn't overturn the laws that we have elsewhere. Article 23 specifically gives the green light for the member states and the EU to legislate for that. But there's also, Article 15.4, which specifically says the right of access shouldn't overpower or outweigh the rights and freedoms of third parties. And that's before we even talk about the specific protected disclosures related exemptions. So, so the only thing to bear in mind really is that while this right can be curtailed, the only answer shouldn't be to refuse to provide any information to the data subject. So what I would say to that questionnaire is make a good faith engagement to facilitate that right of access, provide falling short of the information that would actually compromise the protected disclosure process. Just last thing to say, I remember I was reading one of your articles, actually, Vigjilenca, before this event, and actually saw a good example of that, although I didn't actually look at the case. There was this, I think, German labor court case that involved the court saying ultimately that the right of protected disclosures law couldn't result in a blanket refusal to provide any information to the affected individual. And that's basically the same principle here. It's just, don't compromise the investigation of the disclosure, provide some information, make a good faith effort to engage. And as regards the unfair dismissal, employment law aspect of it, get legal advice. That's all I can say.
Thank you so much, Andrew. And we hope actually in this regard, in terms of your message of get legal advice, that this is also where the TI help resource desk, this virtual resource will be that help, especially if you are in an member organization, and therefore these sometimes legal issues can be challenging. I don't see new open question, so I will sort of abuse my position as this facilitator to come back to Simon in terms of, and sort of bring tie-in together with what Andrew was pointing out within the sort of good example of the Irish law, where Ireland actually perhaps I'm sure the law gets sufficient critical reading from the Irish audience, but externally in the world, Ireland is actually seen consistently as in one of the countries that has better practices, if not best practices, in dealing with these issues. So what I'm trying to say is that while Ireland maybe is very clear and specific in saying that no matter what the scope of what you're reporting, so regardless if that issue is Irish as such or not, you will be protected. Unfortunately, not all member states, while implementing this directive, have taken that sort of above and beyond, to use the word of the conference, approach. So Simon, since we have you here as a guest from Germany, perhaps you can bring in the German example and sort of maybe see how some tensions are coming through in Germany, and where potentially you see the Irish example being better or clearer or not maybe.
That's actually a great question. I think if you're trying to look at different whistleblowing laws within Europe, the Irish one is definitely one of the top ones, one of the best ones. I think the main reason is because Ireland had a whistleblowing law before they were first forced to have a whistleblowing law by the directive. So you have a couple of issues, trying to reconcile the things which have been in the law before, and then which are now trying to conform with the directive. But generally speaking, Ireland is really good. Germany, I'd say, at least on paper, is pretty good as well. They do have some difficulties. The problem in Europe usually starts the further you turn east. Not every Eastern European country, but many Eastern European countries, Poland is one prime example of that, have pretty narrow whistleblowing laws, and much of that can be explained due to their historic experiences under communism. So you still have this, confusion what an informant and what a whistleblower is. So if you look at, for example, the Czech or the Polish discussions around the whistleblowing laws when they were transposed, you had a very different vibe than the one you had in Ireland or other countries which already have experiences with whistleblowing laws. So from a more practical point of view, if you're dealing with countries which have very narrow and in many cases non-conforming laws which violate the directive in many ways, you got to be careful if you have those transnational whistleblowing cases. If you're trying to advise people based on the Irish Protected Disclosure Act and say, well, you're working for us in Poland for a Polish subsidiary, but you're going to be fine because this is basically European law. So it kind of works like our law. Now I'm going to tell you when you would be expected, when you would be protected. That's kind of a dangerous assumption, because if you look into the laws, there are actually quite a lot of exclusions and murky provisions in some countries, which will make it difficult. So the general advice is, if you're trying to advise someone from another country, usually you should get it, specific advice from lawyers from that country, because it can be very hard to tell if there are similarities or differences. Or just to have one concrete example, in France, for example, which has a rather good whistleblowing law, you have one provision which explicitly states you cannot be a whistleblower if you have a personal interest, especially monetary interest, into the case being resolved. So that's something which is clearly violating the directive, but it is there. Again, a cultural issue. So if you have someone blowing the whistle in France in a French subsidiary, and they may get something out of it, maybe some kind of reward or something, they will probably not be protected under the French law if you don't interpret it in conformity with the whistleblowing directive. So those are kind of the alarm bells which should ring if you're dealing with those kind of cases.
Thank you, Simon, very much. So in that sense, actually, I appreciate you bringing the cultural element, because I remember even way back in 2015, we were trying to have these discussions. It was tense even in Germany, because I think out of the countries that you're mentioning, well, Germany actually knows the best in terms of the difficulties of who's an informant and who isn't. And certainly some issues around duty of loyalty to your employer were very much hardcore ingrained, imprinted into German practices. So I suppose what you're saying, and indeed what matters a lot, is that while in the panel we're pointing out to the laws and some of the advices or some of the possibilities around how to handle these things, a lot in the end of the day does come back to practices, does come back to sort of the legal culture or the work culture around where these issues take place. And in this context, I'll come back maybe, Ray, to your point, because as you mentioned before, and certainly Ireland has had experiences in the past, would you like, now we have some time as well, and since I am not seeing new questions, I would like to give back the floor to you. If you'd like to maybe point out any example that comes to mind where you think, well, under the previous, the old law, things maybe were even more challenging in this particular field or area, and under the amended Disclosure Act, you see the promise of that change, or perhaps the reverse, that maybe certain practices or things worked and made sense in the old law, and perhaps now the revised amended law shakes things up that in a way that's not always as welcomed or as predictable.
I think, and not to give too short an answer, I think the problem is that the Act is only come into existence this year. So really, we're really at the beginning, we're at the genesis of trying to discover whether it's better or not. I think it's much more targeted. It's probably building on what the previous act was, and then obviously building in what the European legislation is saying, and saying, well, hold on, here's a few places we can improve. We need to strengthen up, let's say, so for example, where they brought in criminal offences, all of a sudden there's much more heed passed to that. So now, certainly from discussing with other, people from in other businesses and other agencies, there's certainly a lot more, shall we say, cautious about what path they take and where they tread, which is a good thing, because I think that protects the discloser, and I think that's what it should be. I think really it's a kind of a wait and see. Similarly, I've discussed some of them. We can see where some of the conflicts are there. Again, the Protected Disclosures Act versus criminal investigations, what's taken precedent there. Also, while some of those, you could equally argue some of those offences that are made criminal, some of them would directly relate to maybe the designated persons and the way they conduct themselves. So, is that going to create too much of an atmosphere of fear? Because I think we have to see where we want to get with this is, certainly from our Garda Síochána, wearing my own Protected Disclosures Manager hat, is there something within the organisation that's going wrong that we need to be aware about? And that's ultimately where we want to get. So what's the best way of having that revealed to us?
Thank you so much, Ray, and that's actually an excellent message. And coming back to you, Andrew, on this aspect as well, because also in the questions that you answered previously from our attendees, it's wonderful to hear over and over again, in a way, your emphasis on it doesn't have to be an all or nothing. It's actually, there's ways in which we can understand that it can be frustrating or difficult or not straightforward in terms of navigating these lines, but there is a way to kind of walk within these thin ropes. I was wondering if you have any extra thoughts in terms of walking these lines in between these two regimes, from an example, maybe from a practice that you'd like to share, or a specific provision that you'd like to highlight in this regard.
Yes, no problem, Vigjilenca. You notice I sidestepped your previous request for an example. I suppose that's just, I would be wary about, discussing open or closed cases, but it's very true. So the thing that kind of leaps out at me in this kind of public engagement on data protection, where it intersects with other regulatory frameworks, is that there is always what people want to hear is, what trumps what overpowers what, and really, the message is always actually it's more subtle than that. The ways that these frameworks interact is always foreseen and carefully mapped out in the drafting of the legislation. So actually, usually a common sense and pragmatic approach will lead to the actual the managing of these differences. But I suppose just in terms of talking a bit more about our role as a prescribed person and accepting these kind of cases and the sort of issues that come up, I suppose it would be interesting from the perspective of the audience to hear a bit more about the sort of cases that we don't accept, or where our hands are tied, or where things are outside of our remit. And it does tie back to what we were talking about just now, because it is, the main thing to bear in mind, I suppose, is that there will be situations where we won't be able to accept a protected disclosure as valid, either because it raises matters that are beyond our remit. So obviously the DPC can't enforce consumer protection law, or matters that are in the remit of An Garda Síochána, the police, or because it relates to an exclusively personal workplace complaint or grievance. And this is something that we see in the reports that we have to refuse, or not refuse, but deem to be not valid disclosures. They're actually internal HR type grievances that are affecting a single person. And generally speaking, these sorts of grievances should be dealt with internally, or failing that with the Workplace Relations Commission here in Ireland, or through the courts, etc. And another, I suppose, reoccurring theme in the sorts of referrals or reports that we can't accept is where it is a workplace issue in relation to which the individual already has recourse to another route of redress. So what I mean by that is basically, you can't try to repackage a data protection concern as a protected disclosure and submit it to the Office of the Protected Disclosures Commissioner and say, please investigate my concern, as I'm not happy with how the other regulator handled it and the conclusion and the response I received. And these sorts of exemptions are all specifically set out under Section 5A of the amended Act. Now, the sort of issue that this raises is that it can be confusing, in particular for individuals who are unsure of whom to turn to and who is responsible for addressing their specific concern. But the main thing to bear in mind, I suppose, is that making a protected disclosure is not an appeal process, and it's designed to make sure that all the regulators involved, all the prescribed persons, and the Protected Disclosures Commissioner, that we all stay in our lanes and that we work effectively together. It's fundamentally about encouraging workers to report wrongdoing in the workplace where they may be concerned about retaliation, but it doesn't reinvent the wheel when there's already a framework there for making a complaint to the Data Protection Commission, or making a complaint to the Guards or the Consumer Protection Authority or wherever. So this is another kind of transparency explanatory piece that we're still working on, or that we in the DPC are still working on.
Thank you so much, Andrew. And that's actually an excellent point. And one of the things that I've noticed over and over through the research for the countries that have been having laws is indeed this the point that both you and Rainaway are bringing in the Irish context as well, that, and to some extent also Simon is mentioning, in terms of, if we look at this from a perspective of the reporting person, how confusing and intimidating, because we're sort of assuming as if everything else is normal and equal and you're having the very regular day. But actually, if we're looking at cases, sometimes it of course depends on the disclosure, but sometimes when the disclosures are very serious and worrying, it's also quite stressful for the reporting person to know which exact right button to press or which body to contact. Or one thing that I remember from the conversations with Anthony Deltour, which was the whistleblower on the LuxLeaks, which is in a way the background or also fueling of the legal conversation in Europe around protected disclosures and in the end the whistleblower directive, was the fact that he was approaching different NGOs initially. Is this a question around taxes? Is this a question around depending on the field? So in this point, actually, Simon, it relates to the confusions, or in a way the complexities that you were pointing out as well, from a perspective of different companies and branches, but also within even if you're working in a very clear or more local context, that can be confusing. So Simon, I wonder if you have any further thoughts, maybe also from your work and from your research in Germany, in the sense around, to Andrew's point as well, about increasing transparency or clarity of what or where to approach, that you we can imagine situations where the individual in a way is not satisfied and wants to restart the process, but sometimes the difficulty is that you don't even know where to begin. And sometimes, and very important to point out, and I'm sure our attendees have heard this from other panels as well, the good thing with the directive is that there is no obligation for individuals to do this internally first, that they can indeed go externally. And that is a very major important step, and actually a step that was quite difficult in a way to reach in the legislative process. So Simon, bring it back to you in terms of, from the perspective of the reporting person, if you have any further thoughts in giving further advices to organizations of going beyond, above and beyond, as you're saying, of having clarity or really being more comprehensive, but also maybe any other thoughts in terms of knowing which number to dial.
Yeah. What you mentioned is a really important point. Like, I'm sure you know that from your own research as well. I know it from my research and then from the practical advising I'm doing for bigger German companies. The first step is always, have a proper information policy for your whistleblowers. I mean, the directive forces companies anyway to point out that there are external channels and inform about the internal channels, but you really should be going beyond that, especially if you're a company and you want to avoid that external report, because the only way you can really do that is if you generate trust, and the only way you can generate trust is by communicating. So you shouldn't just stop at basically having some kind of broad framework information telling people there are internal and external channels, and that's that. If you really want to make sure that people come to you and stay with you, you should actually have some kind of advisement process, some kind of where people can actually go and seek information before they actually decide to report something. That's something that has worked very well with a couple of German multinationals and other companies in Germany who figured out that if we really, try to initiate the discussion before people are even thinking about reporting something, before they really, take that step and dare to actually make a report, if we have both abstract information available, not just 2 or 3 sentences on our websites, and then we actually have personal personal information and personal advice that we're giving to people, which doesn't have to be documented, by the way. That's something that people tend to be a little afraid of. If you're looking at the directive itself or the corresponding laws, you have to document everything that's coming in, the whole, the whole report, and then everything that comes with it, which some people are just justifiably or understandably a little bit nervous about, because confidentiality is never something that is guaranteed 100%. Once the public prosecutors get their claws on a document, you can't really do anything about it. But if you're in this early stage still, where just advising people whether or not they should actually make a disclosure, you can do that in the most liberal way you want, and you can actually tell people this is not just staying confidential. It's not. I'm not going to even put it down somewhere and have it documented somewhere where somebody else can potentially actually have access to that. At least that's something you can do under the German law. I would assume that's the same under the Irish law as well, but I'm no expert in Irish law. But generally speaking, as a matter of policy, have as much communication as you can, because more communication, the more trust, the more people actually give you useful information, the kind of information you'd like to have.
Thank you, Simon. Well, I know for sure that there's excellent legal scholars in Ireland who are part of this conference, including Dr. Lauren Kierans, who's based at Maynooth University. Is actually also part of the European Whistleblowing Institute, and I'm sure she will also cover precisely the Irish legal dimensions to these points. In our last sort of less than 10 minutes and so remaining, I am making sure that there's no raised hands or questions from our attendees, but I do therefore want to give one final round if our panelists want to leave the audience. One thing that we really want to sort of make sure is that the panel, beyond highlighting and teasing out and really sort of in a way also pointing at so many of the legal challenges or things that arise from the Protected Disclosure Amended Act. Do feel free also to keep on your questions in the other panels and reach out to us further on. But for now, any final thoughts or message, a clear step perhaps, or to Simon's point about building trust, which I could not agree more, is a fundamental to the whistleblowing process. So I'll start in a reverse order from the way we started our panel. So in this sense, Ray, if you have any any final messages or thoughts to share with our attendees?
Well, I suppose we have been speaking really towards, conflicts between, various different acts and various different roles and responsibilities. I think just from the perspective of Garda Síochána, just to give our experience, really, when we come across that, really, it's a value-based approach is what we have in relation to it. So we look at the proportionality, we look at necessity, and we look at legality, and we put all those into the mixer, and to maybe decide as to what's the best approach to take in relation to this. I'm not saying we're always going to be right, but I think if we do that and we have a particular method for, for negotiating our way through any of these conflicts, I think we generally tend to find that tends to work. And just one other thing that I didn't mention there, just in relation to the legislation, and particularly in relation to some of the criminal matters in it. There's a reverse burden of proof now under the new the Amendment Act, which I think is important for people to realise. So it's no longer now, the burden of proof is on, say, the discloser to prove that they've been victimised or whatever. That it's now up on the organisation to prove that they haven't. And I think it's an important little point to make. And I'm sure you'll have a lot of other speakers who may talk towards that on other dates. But I think it's just it should be borne in mind in conjunction with what we've spoken about already.
Thank you, Ray, so much. Actually, that's and I'm so glad you brought that up, because although we don't have time to delve deeper in this panel, it's sort of being addressed overall in the conference. For me, it is one of the points where the directive was welcome, because in that sense, it did signal, in a way, a new stage of protections where it's much, in a way, shifting the balance, that it's not an individual trying to prove that they've been retaliated against, but rather that burden falls on the potential employer who may have done that. Moving on sort of to the last final thoughts from the other panelists, Andrew, I bring the floor back to you.
Thanks, Vigjilenca. I hope you'll indulge me if I give a mention to our regulatory strategy for the period 2022-2027, which sets out the DPC's strategic goals for the next 5-year period, one of which is to bring clarity to stakeholders. And I think that that's a very important objective, which ties into some of the issues that we have been discussing today, to make sure that people understand their rights and entitlements in different contexts, data protection, protected disclosures, freedom of information, etc., and that they are empowered to use those, because I can't tell you how many times I've received an email that says something along the lines of, this is a protected disclosure, I'm requesting my personal data under freedom of information as set out in the 1989 Data Protection Act. And so, this is obviously very bewildering to a lot of people, the regulatory framework, even though, as we've been discussing, the way that it's actually set out and intersects is actually quite pragmatic. But I wouldn't want to give the impression that the onus is on individuals to understand this stuff, and on them to say the right words so that employers or data controllers facilitate their requests. The onus is on all of us to empower the citizen and parse their requests when they don't seem coherent or they make mistakes, so that we understand and facilitate the rights that they are seeking. I suppose we also need to make sure that employers understand how to comply with these different regulatory obligations, that they don't feel overwhelmed, to explain that the regulation is sensible, as I've set out before, and also that, as we've said several times today, to make sure that employees feel empowered to report on wrongdoing in the workplace, even where, from the context, the employer might know who they are, that they trust the protections that are set out in the law, and that they trust that they will apply to them, and that this gives them the confidence to shine the spotlight on wrongdoing.
Thank you, Andrew, very much. And to your point around that, the burden is not on the reporting person to know sort of all the differences. I often say I'm an EU law scholar, and I couldn't tell you where EU law stops and national law starts, because the waters are very muddy. So one sense around a lot of national member states who are in their implementation acts only limiting reporting to the things that are set out in the directive and not being as wide in scope as the Irish example. I would like to say for any attendees that potentially maybe is a also looking at the directive itself, that the preamble explains that should the individual think that the reporting that they're doing falls under the directive, and that is done, and that's reasonably believed to be so, that person would be protected, even if in fact the disclosure is a question of national law and not as such on the policy field covered by a directive. And bring it back to Simon, another key expert on the directive, on national implementation. Simon, any final thoughts in our last remaining 2-3 minutes?
I guess my final thought is just, if you want to go above and beyond, go international. I mean, right now we have like the perfect storm of whistleblowing legislation. For the first time, we got one common piece of legislation in the whole of Europe. Everybody needs to implement it. Everybody is aware of it right now, whether they like to be or not. And secondly, if you're in Ireland, you're arguably in the country with the most influence in Europe right now when it comes to whistleblowing, because you've got the experience, you are very international, your taxes are low enough that Starbucks and everybody else setting up the headquarters in Ireland. So for those ethical leaders who are actually in international corporations situated in Ireland, having influence over the rest of the continent, this is actually the perfect time to actually leave the imprintment of Irish whistleblowing experience for the future on every other country. Be aware that there are other countries which you would also have to keep in mind. Be aware of your subsidiaries no matter where they're actually situated. And if you pursue that in an active way, there's really a chance that you can actively improve the situations for many, many whistleblowers, and actively create and reform whistleblowing laws beyond the scope of Ireland, because in effect you're actually going to influence a lot of other countries as well if in Ireland you're doing it well.
Fantastic, great note also for our Irish audience to sort of be the leader, Europe and globally, in terms of best and good practices. I want, as a moderator, to thank the panelists so much for your excellent interventions, for your clear points, for addressing so many issues in such a tight time. We do hope that it has been valuable to the attendees. And as I say, please do bring forward your questions. And yet again, I'll mention the help desk coming your way from TI. And on that note, also, I'll bring back to Nadia. And I promise you, Nadia and I did not have a protocol how to arrange our dressing. We by accident happened to be dressing in the same colors. Thank you very much once again. Nadia, back to you.
Thanks, Vigjilenca. It's all about empowering the individual. That was a really informative session. Thank you so much to you and to the rest of the panel. Just so much covered there. Yeah, it's a really complex topic, and yeah, just so much to unpick, but lovely to end on what we can do to just go above and beyond, that there's messages of building trust, that taking that values-based approach, and of course, yeah, empowering employees. It's just also really important. I'm going to just share my screen now to let you know what is coming up tomorrow. So just bear with me. So we've got 2 really exciting sessions coming up. In the morning, we'll have our very own Ida Nowers, our Knowledge and Policy Manager here at Integrity at Work, facilitating this discussion on new tools and resources for employers and employees. That will be a really practical session. They'll be discussing confidential online reporting, employer feedback systems, and workers specializing in information and communications technology. And of course, we will make as many of those resources available in the OneDrive folder as we can. And then in the afternoon, we will have, we're going to go legal with this session. It's facilitated again by one of our own training associates, Rory. He's also an employment law barrister, and he'll be chatting to Lauren, who Vigjilenca mentioned earlier, and Emmett, who is a partner at Byrne Wallace, about the most important changes to the legislation. And those changes could change the way workers, employers and regulators share and act on future disclosures of wrongdoing. So 2 really interesting sessions tomorrow. I very much hope you've enjoyed this, our second day of the conference, and looking forward to seeing you all back here at 10 a.m. in the morning. Thank you again to all our panelists for their contributions, and have a lovely afternoon and evening.